This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Where a special relationship exists, for example, an executor may sue to enforce a contract entered into by the deceased. Basic and basic. Now you know what I'm going to ask. You know what the question is. So give me the answer before I ask the question. Say again. Thomas and Thomas, yeah, but what was the first one? Errington and Errington. Errington and Errington. Illustrating, once the acts of acceptance have started, then the offeror cannot revoke the offer. Thomas and Thomas illustrated what, Ganuta? Thomas and Thomas. Let me give you a clue. Pepper what? Peppercorn rent. That consideration must be sufficient, it needn't be adequate. These are in your case lists, where the names of the plaintiff and defendant are the same. And here's our third one. Whatever it is, basic and basic. It's a family case again. This is a case about a man who owns a coal delivery company. So he buys coal from a wholesaler, and he puts the coal in bags, each weighing, well, in the UK it measures 100 weight. 100 weight is actually 112 pounds, and there are 20 of those in a ton, but of course our ton is different than your ton. So let's not get into imperial and metric measurement. So he puts the coal into the bags, he puts the bags onto the back of his big lorry, and he drives around the locality, drives around the area selling these bags of coal. That's what a coal merchant does. And the uncle, in this case, Bezic, had this coal merchant's business, and he said to his nephew, I'll sell you the business. And the terms of the sale are these. If you pay me £6 per week for as long as I'm alive, and then when I die you pay your auntie £5 a week, then the business is yours. Until she dies, then the business is yours. And the nephew thought, yes, okay, I'll do it. And he paid the uncle £6, and then the uncle died. He then paid Auntie, he paid a one lot of £5, and then he said, Auntie, I'm not paying you any more. And she said, well, you agreed in contract with your uncle that you would pay me £5 a week for the rest of my life. And he said, yeah, but because of the principles of privity of contract, only uncle can sue me, and he's dead. So who's going to sue me to enforce this £5 payment? And Auntie said, I will. I'll sue you. And he went to court, and the High Court, said, you can't sue, you have no right to sue. You were not a party to the contract, the original contract. So she appealed it to the Court of Appeal. And the Court of Appeal at the time was headed by a very famous judge, a man called Lord Denning. And he saw reason, he saw common sense. And he accepted that sometimes the law didn't make common sense. What's the common sense decision here? Is it that the nephew should pay the auntie, or is it that the nephew, because of privity, the nephew doesn't have to pay the auntie? What's the common sense? What's the fair decision? A fair decision is that the nephew should pay. But that's not what the law said. The law says you only have rights to sue if you're a party to the contract. So Denning gave his decision in favour of the auntie, and then said to the nephew, now go to the House of Lords. Appeal this case to the House of Lords, and we'll let them work out what my decision, or how my decision is correct. Because it is correct, it's the law being fair, and therefore we'll let the law lords find a reason or a justification for why my decision is the right one. And the law lords struggled with it. 5 law lords in the House of Lords. And these 5 law lords struggled with it, and eventually they came up with the argument that said the legal personal representative of a dead contracting person should be able to sue to enforce the contract that the dead one entered into. So they're suing on the basis that they are representing this dead man. And Mrs. Beswick, Widow Beswick, had been appointed by his will as the legal personal representative. So the law lords created this exception, or Denning created this exception, which allows somebody else to sue to enforce a contract. Clear? Yep. Interesting?
Is it possible because she was the wife of that man?
Is it possible only because she was the wife? No, do you know, I don't think it is. I think I may be wrong, but I think if I die, or when I die, and I've entered into a contract where my wife is to benefit, if I appoint Bernita as my executor, I think that she can sue on my behalf. But I may be wrong on that. But I think it's just any legal person. I don't think it has to be my wife that sues to enforce that contract. I think it's anyone, any legal personal representative. A beneficiary may sue a trustee. Oh dear. Do you know beneficiary, trustee? Do you know what these people are? Do you know? No? Okay. I'm a wealthy man. I've got this £5 note here. And I want to make sure that my daughter benefits from my wealth. But look at her. Irresponsible, sex, drugs and rock and roll. I daren't let her have it because she'll blow the lot on her high life and it'll all be gone. I've got to wait until she's mature enough to spend it properly. So what I'll do is I'll give my property to someone to look after. And he's the trustee. This is the trust property. He will look after this property on her behalf until the time which I have said I think she will be mature enough. And looking at her, probably another 10 years or so. So you, the trustee, will look after this trust property on behalf of my wishes, but you're looking after it so that the beneficiary will ultimately benefit from my wealth. You can claim your expenses, you can get ordinary expenses, and you don't have to do anything with it. You don't have to invest it and try and make it grow. You can, but you don't have to. So you look after that, and then the years pass, and when Sandra reaches the 10-year age, she can then contact the trustee and say, I want my money. So the beneficiary can sue the trustee even though I am in contract with the trustee and she isn't. Okay, a beneficiary can sue the trustee for the recovery of trust property. Okay? That's illustrated by the case, or a couple of cases, Keach and Sandford, Shamia and Jury. I don't want to go into them. There are stories. One's about a market stall in Romford in Kent, and the other is about an Iraqi student living in England, and his brother is in Iraq employing an agent in England. The other way around. His brother is an agent in Iraq employed by a merchant in England. The merchant owes the brother in Iraq. He wants to send money to his brother in London. The brother says to the merchant, don't pay me, pay my brother. So the money doesn't have to go to Iraq and back again. You just pay it in. No. A beneficiary. Sandra can sue Eddie. That will do. Manufacturer of goods may be sued by the ultimate consumer. This like Carlisle, this is one of the cases that you will take with you to your own grave. I don't want to talk about your death. I don't mind talking about my death. But this is a case that you will remember. All right? This is about a man in Glasgow and his girlfriend. And they're out for a walk on a Sunday. And they stop in a cafe in the park. He says, "Do you want a drink, darling?" And she said, "Yes, I'll have a ginger beer." Now, a ginger beer is a soda drink, and it tastes of ginger, so it's a bit sharp, and it comes in a brown bottle, and you can't see through the brown bottle. It's opaque, it's not transparent. So he got her a ginger beer, and he got himself a pint of beer and a whiskey, just in case he wanted both. And he took these back to the table, and being a true gentleman, he poured half the ginger beer into her glass, and she sat there, and he drank his beer and he drank his whiskey. And, "Do you want another? Are you all right with that? I'll just go and get a beer." So he got another beer and got another whiskey, came back and poured the remainder of the ginger beer into her glass. But it didn't pour smoothly. It didn't go, it went, blah, 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 blah. And the last, blah. Something black and slimy, slippery slime, came out of the bottle and settled at the bottom of her glass. And she looked in this and said, "What's that?" And he said, it looks like the remains of a dead snail. You know, snail, the little thing with a hat on. It looks like the remains of a dead snail, which has obviously got into the bottle somehow, and you've just been drinking it. So she was violently ill. Projectile vomit. And he said, "Careful, mind my suit, mind my suit." She was dirtying the suit. So we've got a problem. She's suffering mental trauma. She's really, really mental. I've been drinking dead snail. And he's suffered a dirty suit. And a lunatic girlfriend. So who can sue who? Who can sue who? She can't sue the cafe owner because she's not in contract with the cafe owner. He's in contract with the cafe owner, but he's not suffered anything. He may be able to sue the cafe owner for the dirty suit, but it wasn't the cafe owner that caused the dirty suit. It was his girlfriend, and they're not in contract because she didn't pay him for the ginger beer. So she can't sue him, or he can't sue her. She can't sue the cafe owner. He can't sue the cafe owner. The manufacturer is not involved in this contract at all. He's involved in a contract with the supplier, with the cafe owner. So who can sue who? And it comes down sensibly to this, that where somebody manufactures goods which are then ultimately consumed by the ultimate consumer, if those goods are faulty or poisonous or not acceptable, the end user, the end consumer, should be able to sue the manufacturer. And this was the first case where it was accepted that this could happen. And she was therefore able to sue the manufacturer of the ginger beer. Even though she's not in contract, an end user can sue a manufacturer. Employer may be sued for the negligent acts of their employees. This comes in employment law. If an employee acting in the course of their employment, if they're acting outside the course of their employment, if they're not in their workplace during their work hours and doing the things that they're being paid to do, if they're doing something else, then the employer may avoid liability. But if they're in their workplace and they are in the course of their employment and they are doing the job that they are paid to do, then what's the point of suing the employee? If that employee negligently causes damage or harm, what's the point of suing an employee? I'm not interested in your personal wealth, but we'll just take Leanna as an example. If Leanna, in the course of her work, causes damage or harm to me, there's no point in suing Leanna. She's not got £3 to rub together. If I win and take all her wealth, she's only going to be able to pay me £3. But I can sue her employer. And her employer must have insurance. Must have insurance called employer liability insurance. And they must have employee liability. They are insured against the loss that employees cause to the world at large. So the negligent acts of an employee may allow me, who has suffered, to sue her employer. Her employer didn't commit the negligent acts, but it's called, the liability of the employer is called, it's a strange word and I doubt whether you'll know it, it's called vicarious. Vicarious liability. The employer is vicariously liable for the negligent acts of the employee. In this case that you have in front of you, Mersey Docks and Harbour Board and Cargins, or Mersey Docks and Cargins, is about a crane driver. And he was employed by his employer, but he was subcontracted with his crane to work for Mersey Docks. And he caused negligence, he caused loss, and so the subcontracting people who are hiring his skills, they were now caused loss by the negligent acts of the crane driver, so they sued his employer. Mersey Docks sued the original employer, Cargins, for the negligent acts of the crane driver. Well, that's clear, isn't it? No. I employ you, but I subcontract you to another employer. By your negligent acts, you cause this other employer damage. It's not worth the other employer suing you because you have no money. So he sues me instead. Okay, all I want is you to ask. If you ask, I will tell. Not necessarily everything that you ask me, but most things that you ask me.
You are subcontracted and you cause some damage to a third party,
then the same again. If she is a subcontractor, if I've subcontracted her to another employer and she causes damage to an innocent bystander, then we have a decision. Who employs her? Who is her employer? Who is her employer? And that's what this case actually was about. Who is the employer of the subcontracted employee? And the court said an employer is not a good, a product, to be moved from one person to another, and therefore they stay the prime employee of the original employer. Restrictive covenants. Oh, we came across the word covenant earlier, didn't we? Didn't we come across, wrote covenant on the screen, didn't I? Didn't I, Benita? Did I not write covenant on the... What were the two words that came in front of covenant? It is a specialty contract. The two words that came in front of it were deed of. A deed of covenant is a promise. And to be enforceable, it has to be signed, sealed and delivered. A restrictive covenant is a restrictive promise. If I own land, this is about the area called Leicester Square in London. And a former owner, I think maybe back in the 17th or 18th century, a former owner of this area called Leicester Square put a restrictive covenant on the document which passed the title of the property. And he put this restrictive covenant on. It said Leicester Square shall only be used as a pleasure garden and for entertainment. And that's why if you ever do go to London and you want to go to a theatre or a cinema or buy tickets for a theatre or cinema, all the theatres and cinemas are there in that area of Leicester Square. It cannot be used for commercial business. It cannot be used for manufacture. It can only be used as an area, a centre for pleasure and enjoyment. One might say that that's possibly where the pleasurable young ladies of London also work. Possibly, I don't know. But this is the case. Tulkan Moxey, this previous owner of Leicester Square, put a restrictive promise that said Leicester Square will only be used for pleasure activities and entertainment. And it means that subsequent owners who buy the property in Leicester Square, subsequent owners are bound to restrict their activities according to this restrictive covenant. And you can't turn around and say, well, I bought this property in the year 2011 and I'm not a party to the original restrictive covenant. This was created 200 years ago. Doesn't matter. If it's attached to land, as in the restrictive covenant prevents the free use of land, then I have to respect that restrictive covenant. Even though it's nothing to do with me, I have to obey that restrictive covenant. Collateral contracts, an injured party can sue even though the other party isn't a party to the contract. Shanklin, Pier and Detail Products. Detail Products is a paint company. They manufacture paint. Shanklin Pier, a pier is a construction which sticks out into the sea or into the water. They're often great long things with buildings on and cafes and entertainment booths, and they stick out maybe half a kilometre, 3/4 of a kilometre into the sea. And in Victorian times, when Queen Victoria was on the throne, they were very popular, and people would go to the seaside for a holiday, and they'd walk. I've done it myself, but I can't imagine why I would ever want to do it again. And you walk along the pier, and you get to the end, and then you walk back again. And what on earth? Why? It's bracing. It's the sea air flowing through your healthy lungs. So, Shanklin Pier, I think it's in the Isle of Wight, a little island off the south coast of England. They wanted their pier painted. It was time that it had a paint job done on it. So they contracted a painter, and Detail Products, the paint manufacturers, had visited Shanklin and said, we've got the ideal paint for your pier. Our paint is super, it's seawater resistant, it'll last you 20 years, it's an excellent paint. So Shanklin contacted a painting company and said, we want you to paint our pier and we want you to use Detail paint, Detail Products paint. So the painter bought the paint. They went to the pier company and painted the pier. The paint was useless. It washed off. It was no good. The rust came through. The paint was useless. So Shanklin now sue Detail Products and say, your paint is useless. And they said, you can't sue us. We've never been in contract with you. We were in contract with this painting company, not with you. And the court said, can they sue or can't they? It's a collateral contract. Because we had been induced, led into specifying Detail paints, and because they knew that we were going to specify Detail paints to the painting company, then we are effectively in contract with the paint company. And it's a collateral contract. Although I'm in contract with the painting company, I've specified this particular type of paint that they've persuaded me to, and therefore I can sue the paint company. Shanklin Pier can sue in a collateral contract, collateral, two-sided, three-sided, or two contracts running side by side, and then I can sue even though I'm not a member or party to the contract. Pinole and its exceptions. Pinole's case is a 1604, I think, 1604, give or take 2 or 3 years. I think it's the early part of the 17th century. Dates are not important. There's no need for you to know any dates. But Pinole is the case I was mentioning earlier about it being historic. It's 400 years old, and it still is applicable, and the principles which it established are still applicable principles. And Pinole says that where a debt is owed, part payment of that debt does not get you good discharge. Even though the other person may accept part payment, if I owe you £100 and I have to pay it today, and I pay you £70, but listen, I can't afford 100. Will you be happy with 70? And I pay you the 70 today, and you reluctantly agree, okay. And then I can later afford to pay you the other 30. Can you sue me for that other 30? Do we care? We do care. We're not just sitting watching that red finger go around the clock ever so slowly. We're not just doing that, are we? No. It's just that I was getting that impression, that was all. Do we care whether you can sue me for the extra £30? Can you sue me for the extra £30? What does Pinole say? Pinole says that part payment of a debt is not good discharge. I still owe the balance of the money. So when I do come into some more money, then you can sue me and get that. Okay, that's Pinole. Part payment of a debt does not get good discharge. But there are exceptions. Sometimes it does get good discharge. Sometimes the debt is clear by part payment.
So, did I understand you correctly? So, when I receive the remaining amount, the 30?
You can sue me. According to Pinole, you can sue me and get the remaining 30.
It's when I have received only the first one.
If I've only given you 70 and you have agreed to accept 70,
Yeah, but they still can sue.
and you say, yeah, okay, I'll accept the 70, and then I come into more money, you can sue me for the extra. Even though you agreed to let me off the other 30, you can still do it. Okay? Because it makes common sense, surely, that part payment of a debt doesn't get you good discharge. If I owe you 100, I owe you 100. But there are exceptions. I owe you 100, but I can only afford to pay you 70. But I do have a plastic cup. A rare Ming Dynasty plastic cup. So there's £70 in a plastic cup. Do you accept that? You agree to accept that? Reluctantly, yes, okay, you do. That's good discharge. Something different in kind. I owe you £100, but I offer instead to paint the outside of your house. I can't afford £100 cash, but I do have some spare paint from painting this pier. I've still got some of that paint left. So if I paint the outside of your house, that's something different in kind. If I provide a service to you, if I write up your accounting records, if I give you legal advice, if I take you out for a meal or a drink or something different, doesn't have to be £100. If I take you out for a meal, can we call the debt finished? Yeah, okay. Then that gets good discharge. So something different to which you are not already entitled, or goods instead of cash. I owe you £100. It's payable on the 4th of April. Will you accept £5 on the 28th of March, full discharge? Yeah. Well, it's up to you, isn't it? Is £5 plus 1 week the same as £100? Well, you've got the use of that money. It might be that you're desperate for £5 and that you're able to buy a Ferrari because you've entered into a contract with some lunatic and you can get it, and you need the £5. So it might be a very great use to you. So you may be prepared to accept a substantially lower sum earlier than the due date of payment. That gets good discharge. You've got the benefit of using this money. Even if you only put it in the bank and earn 2% interest, you've had the benefit of that money before you would otherwise have had that benefit. So that does get good discharge. Settlement before the due date. An arrangement with creditors generally, where a company is in financial difficulty and a liquidator is appointed, or an administrator would be a better example, where an administrator is appointed to try and rescue the company, what he will do is he will call a meeting of creditors and he'll say, listen, we have two choices. We can either kill the company, in which case you're not going to get a lot of money. There's going to be very little left for you. Or we can try and make an arrangement whereby I will promise to pay you 20 pence for every pound that I owe you. Now, if you will reduce my liability by 80%, it means me as the administrator of the company, I've got a chance of turning this company round and letting it grow and develop again into the future. So not only do you get your 20 pence today, but you also have a continuing customer, so you can continue to supply me in the future, and that will give you the some benefit of the 80 pence you're losing. But you've all got to agree, or 75% of you by number and by value must agree to that arrangement. Would you agree that I just pay you 20 pence for every pound I owe you? Are you in agreement? 75% by number and by value? Because if you are, if just you agree and you four disagree, if 75% do agree, then you are also bound to accept that agreement, that negotiation. And that does get the administrator complete discharge. The debt is eliminated. The rest of the 80 pence is eliminated. If you don't agree, I'll put the company to liquidation. You'll probably finish up with maybe 15 pence in the pound. Because don't forget, I want my salary. So all the assets of the company I sell, substantial amounts of it are going to feed into my pockets. So there's not going to be much left for you. So you would probably agree. Payment by someone other than the debtor. Sandra owes Benita 5 lats, or 10 pounds. Sandra owes Benita £10. Listen, that's full settlement of Sandra's debt. Take it or leave it, it's up to you. That's all she's paying you. I'm paying it on behalf of Sandra. Are you going to accept that or not? Say yes. Yes, I am, says Benita. Okay, Sandra's debt is now discharged. So somebody paying a debt on behalf of someone else, a lower amount, gets good discharge for the original debtor. Payment at a different location. We did agree that you would pay me when I came here, that I would be paid whilst I was here, and John owes me, as a result of my efforts this week and this weekend, John owes me the vast sum of £140. And he's agreed that he will pay me £140 here on Sunday. If instead he pays me at my request, I want the money paid in my home city, if he pays me a lower amount, that gets good discharge. I have asked him to pay me in my home city rather than as originally agreed here. The payment of a lower amount gets good discharge. Only if it's my request. Yeah, it's at my request that he's doing that. The doctrine of promissory estoppel. It's known as the High Tree, or the illustration is known as the High Trees House case. Central London Property Trust and High Trees House. The doctrine of promissory estoppel says that where a promise is given and acted upon, then the promisor cannot go back on that promise, cannot change that promise later to the detriment of the promisee. And the High Trees House case will illustrate this. But, all right, I'll tell you about the High Trees House case. We just about have time. High Trees House case, a big apartment block in London. In about 65 years ago, 70 years ago, a big apartment block. And High Trees House is renting this property to Central London Property Trust. High Trees House are the owners. They're renting it to Central London Property Trust. Central London Property Trust are then subletting apartment by apartment to people who want to live in Central London 70 years ago in an apartment block. Where is the last place that you would want to live 70 years ago? 70 years ago, it gets me to 1941. I know you won't remember, but you may know from your school lessons what was happening in 1941 in central London. Yeah, we were at war and Germans were flying over and trying to knock down big buildings just like this. So the last place you would want to live probably is at the top of a high-rise apartment block. And so central London were finding it very difficult to get rental, and if they can't get the rent from tenants, then they can't pay the landlord, High Trees House, the full amount. So they approached High Trees and said, listen, we're having problems. We can't pay you $2,500 a year. Will you drop the rent? So it went down from $2,500 down to $1,250 per year. That means that we are able to reduce the rent that we're asking from our own subtenants. We're able to achieve an income sufficient to pay that $1,250. And that's what happened. A promise was given by High Trees House. Yes, we'll reduce the rent down to $1,250. The promise was acted upon. We took this promise, and on the strength of that promise, we reduced the rent to our tenants, who then paid us, and we then paid, we did pay $1,250 each year for 1942, 43, 44, 45. But at the end of 45, the war finished. And therefore we were able now to achieve full tenancy. Circumstances which had given rise to the need for this promise, those circumstances had gone back to the original situation. So High Trees House then issued an invoice, and they said, for 1945, you owe us £2,500 again. We're back into the normal situation. But what about 1941 to 1944? We've got 4 years of the $1,250 that you have not paid us during this 4-year war period. So now you owe us another $5,000. There's our invoice to $7,500. Part payment of a debt does not get good discharge. But the doctrine of promissory estoppel says, where a promise is given, we'll reduce your rent by half. And acted upon, we've reduced our own rents to get full tenancy so we can pay this half rent. Where a promise is given and acted upon, the promisor, High Trees House, cannot go back on that promise to the detriment of the promisee, to the harm of the person to whom they have made the promise. Yes, you can claim $2,500 because circumstances are now back to normal. But you can't claim this 4 lots of $1,250. Promise is given and acted upon, you can't go back on that promise. That's the doctrine of promissory estoppel. Coombe and Coombe, I'm just trying to remember, I think I'm right. Oh, Coombe and Coombe is... Coombe and Coombe is it 4? Yes, a 4. Coombe and Coombe is 4th case where plaintiff and defendant... What were the others? Linda, amaze me.
Errington.
And who was the plaintiff? The defendant? Errington, yes, well done. Thomas and Thomas. It's a strange pronunciation of... It's a strange pronunciation. The way the name is spelt, you would say it should be pronounced Beswick, but it's not. The W is silent. It's a silent W, so the pronunciation is Beswick. Beswick and Beswick. And where Harry Potter films were filmed, the Hogwarts School is in a castle in the northeast of England called Alnwick. But it's not pronounced Alnwick, it's pronounced Alnwick. So not only is the W silent, the L is also silent. So Alnwick Castle. Coombe and Coombe, I think I'm right on this one. Coombe and Coombe is where man and wife are separating, divorcing, and in the divorce agreement says that he will pay her £5 a week for as long as he is able. He did. He paid her £5, and then he paid her another £5, and then he said, I'm no longer able. And so she sued, and the court said, are you able to pay? And he said, no. Okay, that's it. So although there was a promise given, it was so vague that it was not enforceable promise.